Sarmona, shall we start now? Or shall we wait for a few more minutes?
I don't know. We can start now also. We
Hmm.
have started recording the meeting.
Okay. Okay, then it's 7 o'clock anyway, so I think we should start the webinar. And okay, good evening. I am Dr. London Jangkhongam, Assistant Professor in the Department of Political Science, Government Jabwana College, and I will be your host for tonight's webinar. And I am delighted that this international webinar on the constitutional status of the indigenous peoples of USA and India in comparison has become a reality. And our session tonight is recorded and the video will be uploaded in the college YouTube channel. And first of all, I welcome all the participants on behalf of the college, Government Jabwana College Lunglei, Mizoram. And it is unfortunate that our principal, Professor J. Zorama, could not log in due to some power failure in Lunglei town. So anyway, under his able administration and his leadership, our college has reached new heights recently, particularly with the 2.27 CGPA NAC accreditation with a B grade. And Government Jabwana College is a small college in the heart of Lunglei town of Mizoram with a little over 500 students. And there are about 40 faculty members and 10 non-teaching staffs. And so since there is not going to be any separate welcome address by the head of the institution, so I will straightly call Professor Doungel, the resource person for tonight. And before we call him, I am pleased to introduce to you Professor J. Doungel. He is a distinguished and renowned academician in the field of constitutional studies, particularly the sixth schedule of the Indian Constitution, Indian federalism, autonomous governments, local governments, and Northeast studies. And he is presently professor in the Department of Political Science and also Director of Internal Quality Assurance Cell, IQSC, both in Mizoram University. And he is presently Fulbright Senior Research Fellow in the Department of Political Science, University of Cincinnati in Ohio State of the United States of America. And his Fulbright research is on the topic, Constitutional Safeguards of the Indigenous People, a comparative analysis of the Native Americans in the Constitution of the USA and the tribals under the sixth schedule of the Indian Constitution, which is very much similar to our topic tonight. So his contribution in the field of research is quite ornate, and Professor Doungel has completed one UGC minor research project in 2010 and one ICSSR major research project in 2016. And he has presented 75 seminar papers in various seminars of international, national, regional, and state levels across the country. And he has chaired 27 technical sessions in various seminars and conferences, evaluated 23 PhD theses and 8 MPhil dissertations of different universities. And he has successfully guided 4 PhD and 10 MPhil scholars, and currently has 8 PhD scholars working under his guidance. And Professor Doungel published 28 research articles in journals, contributed 25 chapters in edited volumes, and 4 papers in seminar proceedings. And he authored 4 books, edited 1 book, and co-edited 2 books. Of these, 2 of his authored books are in Mizo language. And he is now a member of the Mizoram Local Government Panchayati Raj Drafting Committee, under the government of Mizoram. He is also a member of the Mizoram Boundary Committee and Mizoram Boundary Study Group Subcommittee. And my relationship with Professor Doungel personally dates back to 2013 when I worked as a research associate in his ICSSR major research project. And I also completed my PhD in Mizoram University under his supervision. Now let me call upon our resource person to make his presentation. And dear participants, if you have any question, please drop it in the chat box or in call messages, and it will be answered by the professor after his lecture. So Professor Doungel sir, you may start your presentation.
Okay. Thank you. I'm thankful to JB College for organizing this important program, and particularly to the principal and my scholar, Dr. Nandika Namte, for taking the initiative. And it has been announced by the moderator tonight. It will be tonight for you, but it is morning for me. Anyway, our deliberate on constitutional status of indigenous people in the United States and India. That will be a comparison. And indeed, it is a vast topic. So I should try to be brief as much as I can so that I may be able to touch all the points. First, the lecture should be divided into 3-4 parts. First, the introduction. And after that, historical background of indigenous people of both countries. Then after that, political system of the tribal nation government of the Native Americans. Then political system of 6th schedule to the Constitution of India. And after that, I'll deal on the comparative analysis, then the conclusion. Okay, in such a way, the lectures proceed. Okay, not to lose time, let me start with the introduction. So what is meant by indigenous? The word indigenous, it is derived from Latin word indigena, which means originating naturally in a particular place or land. And the term was first used by European colonizers to differentiate the native people of America, Native Americans, or whom we identified and called them as Red Indians, from the blacks or Negroes or African Americans who were brought from Africa as slaves by the European powers. And this term indigenous mainly refers to people who originally inhabited the territory, who are the real natives of the land, but who are later on overpopulated by the colonial immigrants and who are marginalized. And the term indigenous or people are also known as First People, Aboriginal people, Sons of the Soil, Tribal people, Native people, Autochthonous people, Local people, and Original inhabitants. And many indigenous communities are now marginalized in their own ancestral land, and they face extinction also. And these native people, they lost their traditional land to the immigrants, and they are subjected to extreme discrimination in their own native land, which they had occupied since their forefathers' time. In the midst of these ongoing atrocities, human rights violation, and discrimination against the indigenous people, constitutional safeguards have been provided to indigenous people in United States of America and India, with which we will be dealing with. Okay, now the second part. Historical background of the Native Americans. The origin of the Native Americans cannot be accurately traced by anthropologists, archaeologists, historians, and scholars of different streams due to lack of written record. Researchers and specialists in the field generally believe that forefathers of Native Americans might have migrated across the Bering Straits land bridge from Alaska, from Siberia to Alaska. Alaska and Siberia, the distance between Alaska and Siberia in their closest point is now 56 miles only. Geologists believe that man could reach the New World due to ice sheets which are locked up in the form of glacier ice, because immense amount of planet's water supply in that ice block lower the sea level during ice age. And before that ice block melted, the distance between Siberia and Alaska were linked by dry land. And that dry land, which linked Siberia and Alaska at that time, it was known as Beringia Land Bridge. And through that Beringia Land Bridge, ancestor of the Native Americans, they traveled from Siberia to Alaska and occupied the whole American continent. So the Native Americans occupied American territory for many centuries, both North America and South America. But the situation became different with the discovery of the New World by Christopher Columbus in 1492. Then European powers, namely Spanish, Portuguese, French, Dutch, and English, they arrived America for land, territory, and for fame. Subsequently, the Native Americans were overpowered, marginalized, discriminated, and ruled by the European powers. However, one thing which should be known is that the Native Americans were not uniform in their setup, political governance, family lineage, inheritance, religious practices, language, custom, and culture. But one common thing which was found among the Native Americans was that all adopted collective ownership of land, and land was owned by community, not by individual. They were all governed by chiefs, but the system of chieftainship was also different. Some of the tribes, like Comanche, Choctaw, and Creek, they followed a matrilineal system of chieftainship and matrilineal system of inheritance, like the Khasis, Garos, and the Jantias in Meghalaya. But many other tribes, they followed patrilineal system of family lineage and patrilineal system of inheritance of chieftainship also. And many political philosophers, they regarded the Native Americans as noble saviors of the contractualists. We know the contractualists, Hobbes, Locke, and Rousseau. But it was not like that. They were not noble saviors. They had a rich culture, social system, and rigid political governance. And one thing about this, the Native American, was that the term with which they were never familiar, they were identified with that term. Because after Christopher Columbus arrived the West Indies, he felt that he arrived India, East Indies. He called the people Indian. And from that time onward, the Native Americans came to be known as Indians. Then afterward, they were known as Red Indians. And now the term Native Americans has been used for naming them. But in many writing and in many write-up, they are still identified as Indian. And in American literature or in American research work, whenever the term Indian is used, it does not indicate the people of India. It indicates these Native Americans, the Red Indians, that we should take into account. Whenever the term Indian is used in American context, it always refers to the Red Indians or Native Americans, not the people of India. Then these European powers, Spain, Portugal, France, Netherlands, and England, they allied with different Native American tribes. There were many Native American tribes, and now there were 574 federally recognized tribes. That means tribes recognized by the federal government. The total number is 570. Then 20 tribes were recognized by some state government, and there were already 100 unrecognized tribes. That is their status. So among the European powers, Spain and Portugal, they were the first to enter this Native America. And in fact, even Christopher Columbus was sponsored. His voyage to the was sponsored by the King of France. I mean, the King of Spain. Then these Spain and Portugal, they were given edict by Pope in Vatican to occupy the land and to Christianize the people with Roman Catholic faith. So they felt that they got some holy edict to occupy the land. But other European powers like France, the Netherlands, and England, they didn't pay any heed to that edict issued by the Vatican. So struggle for power of the European powers, European people in Europe extended to this America. The European powers, they fought themselves, and in their struggle for supremacy, they aligned with different Native American tribes, and they also involved the Native American tribes in their struggle for supremacy. And at the outset, there was struggle for supremacy between Spain and France. Then after that, England intervened. Then England evicted the Netherlands and inherited all the land and alliance of the native tribes from the Netherlands. Then struggle for supremacy continued between England and France. And England and France, as we know, in war history, they had 100 years war in Europe. And they also have fought war in India for territory. So their war in India and Europe extended to America again. And in this struggle for supremacy in America also, England was in the upper hand. And by the Peace of Paris of 1763, France ceded Canada and all its claimed territory east of Mississippi River to England and get the city of New Orleans and all its claimed territory west of Mississippi River to Spain. So England was also expelled. First was Netherlands, then England. Then Spain and England remained. Then all colonies of France in North America was inherited by England, including the Native American administration. So North America was in the hands of England, and South America in the hands of Spain. And Spain also recognized the authority over North America. And in such a way, even now, this North American continent, it became English-speaking region, and all the South American continent, all the South American countries, except Brazil, are all Spanish-speaking people. And as England strengthened its position, so in order to increase the royal trade in London, the government imposed many taxes, but simply paying tax without representation in government was no longer accepted by the American colonies. And due to that, some form of struggle was done by the American colonies. Then one of the most striking opposition by the American colony tea tax. That means high tax was imposed on tea to reform and to rebuild the decaying East India Company. This was opposed by the American colonies with the slogan, no taxation without representation. And as this opposition was going on, American colonies, dressed as Red Indians, they threw away the tea of East India Company ship at Boston 1773, which was Boston Tea Party. And as a result of Boston Tea Party, the struggle between American colonies and the mother country intensified, which led to American War of Independence. And in this American War of Independence, France got the opportunity to take its revenge upon England by helping the American colonies. And this American War of Independence was an end with the signing of treaty which was known as Treaty of Paris on September 3, 1783 by delegates of Great Britain, United States, and France. And by this treaty, independence of United States of America was recognized. And after that, all the territories of North America and administration of the Native Americans passed over to the hands of the United States of America. But the emergence of this United States of America was beginning of discrimination and nightmare for the Native American tribes. So that was how these United States of America emerged, and how these governance and land of the Native American tribes passed on from England to United States of America. Then the historical background of indigenous people of India. So far as indigenous people of India is concerned, indigenous people of India can be classified into two. Indigenous people in mainland India, who are known as Adivasi, and indigenous people in Northeast India. The difference between indigenous people of mainland India and indigenous people of Northeast India is that these indigenous people of Northeast India, they are closely allied to people of Southeast Asia, and they are Mongoloid. But that is not the case with these indigenous people of mainland India. And in this comparative analysis, the comparison will be between indigenous people of USA and indigenous people in Northeast India. And so far as northeastern part of the country is concerned, this northeastern part of the country comprised of 7 states, and now it is 8 states with the inclusion of Sikkim in the region in 2002. And this region is entirely isolated from the mainland India and connected with mainland India by just 22 kilometers corridor at Siliguri, which is known as Chicken's Neck. And as I've mentioned, the tribes in Northeast India, they are Mongoloid race, and they are different from those tribe and tribal in the mainland India. And the British East India Company came so close to the boundary of these tribal inhabited territories, indigenous inhabited territories of Northeast India, with the acquirement of Diwani of Bengal, Bihar, and Orissa by Robert Clive in 1765. And during that time, there was no organized administration in Northeast India. And the whole Northeast India was occupied by the Burmese. The Burmese invaded whole Northeast India. And the British felt that Burmese stood in the way for their expansion. So there was First Anglo-Burmese War from 1824 to 1826, and the Burmese were defeated and they were driven out from Brahmaputra Valley and Manipur Valley. And as a result of that, one treaty was signed between the British and the Burmese, known as Treaty of Yandabo on 24th February 1826. And this signing of the Treaty of Yandabo paved the way for expansion of colonialism in Northeast India. There was no province of Assam. And tribal territories in Northeast India, they were neither part of India nor part of Assam in pre-colonial era. But this province of Assam was creation of British colonialism for its own administrative conveniences. And after tribal territories were included in the province of Assam one after another. Garo Hills was the first to be annexed in 1922 before the signing of the Treaty of Yandago, and other tribal territories were annexed only after the signing of Yandago 1826. Gwalpara was added in 1826 as a separate district. Kasar was annexed in 1832. Khasi Hills was annexed in 1835. North Kasar Hills in 1854. Naga Hills in 1866. Zentia Hills in 1883. Northeast Frontier Tract near far or present Arunachal Pradesh was occupied since 1842 and annexation was completed in 1914. Luce Hills was occupied since 1890, but it was annexed to British Empire officially on 6 September 1895. And after the British annexed these hill territories, the British authority came to know that these tribal people in the hill territories, they had their own custom, culture, different political system of chieftainship. They were never under the influence of plain Hindus and Muslims. They were never ruled by plain Hindus and Muslims. They had their own system of administration and they had peculiar custom and culture. So the same law and order which were enforced in the plain area may not be applicable for these people. Due to that, the British authority enforced and enacted certain acts, rules, and regulations specifically for governing these tribal people, indigenous people in the hill territories. So some of those exclusive regulations and laws and acts for governing these tribal territories were Regulation 10 of 1822, Garo Hills Act of 1869, Bengal Eastern Frontier Regulation 1873, Schedule District Act 1874, Chin Hills Regulation 1896, Government of India of 1919, and Government of India of 1935. So since pre-colonial era, these indigenous people in Northeast India, they had their own system, which was upheld and protected by this by adopting exclusive laws and regulation, and the system continued in the form of sixth schedule after independence. Okay, now we'll move on to constitutional status of indigenous people in United States. So, United States of America has a very short constitution. I may show you. This is the Constitution of United States of America. So, compared to India, it is very small. And one can read it minutely in less than 2 hours. So this is the Constitution of United States of America. This is the original Constitution, which is published by federal government. And it is a brief and short constitution. So every detail, every minor detail is not written here in the Constitution. Due to that, most of the practices depend upon convention and traditional practices and interpretation of the Supreme Court. And in this Constitution of United States of America, the provision concerning the Native Americans are found in Article 1, Section 2, Article 1, Section 8, Amendment 5, Amendment 10, Amendment 14, Section 2. So, in one article and 3 amendments, the provision concerning the Native Americans are incorporated here in the Constitution of United States of America. And something also has been mentioned in Article 3. In Article 3 also, something has been mentioned about the Native Americans. Then in the Declaration of Independence also, in the wordings in the Declaration of Independence, mention also has been made about the Native Americans as Indians. As I've said, whenever the word Indians is found, it does not concern the people of India. It is about the Native Americans. So in the Declaration of Independence also, Indians, the native people, were mentioned as Indians. Then in Article 3 of the Constitution gives power to the Congress to regulate commerce with foreign nations, Indian tribes, and between the states. Then on the basis of provision provided in this Article 3 and Article 1, about 390 treaties had been signed by Native American tribes and federal government of the United States. And on the basis of those 390 treaties signed with different tribes, reservation had been established. Reservation and tribal nation government had been established for different tribes who signed treaties with the federal government. So as a result of these treaties, about 300 reservations had been established across 27 states of USA. And now most of the reservations are discontinued. There is no longer reservation among the native tribes in Oklahoma State. I visited Oklahoma State in the month for 10 days in field work, and reservation no longer exists in local Oklahoma State. But in some other state, reservation still exists. And even those tribes who no longer have reservation, they still have their own government, tribal nation government. And now there are 159 tribal nation governments in different 27 states of USA. And the existence of these tribal nation governments and reservations could be traced back to the treaties which the federal government signed with the native tribes on the basis of Article 1 of the Constitution of United States of America. As I've mentioned, Constitution of US, as it is not a detailed constitution, it cannot, every minor details concerning the Native Americans are also not found in the Constitution. And one thing that I would like to add here is that these native tribes, as minor details are not found about their functioning, responsibilities, and powers, for their functioning, they draft their own constitution. They have their own constitution. One thing that we have to know is that in the American political system, there is federal constitution, Constitution of United States of America. Then every state has its own constitution. And after that, the native tribe also have their own constitution. And these constitution of the native tribes are drafted by them, and which has been approved by the federal government, and functioning, power, responsibility, and status of the different Native American tribes and their tribal nation government depend upon how it is incorporated in their own constitution. And one thing that I would like to mention more is that these Native American tribes, they have their own constitution, they have their own flag, and they have their own citizenship. So we know that US has those citizenship for federal, citizenship for state. But for Native Americans, it is triple citizenship. Citizenship, state citizenship, and tribal nation government citizenship. Then we know that with regard to flag also, there is flag for the federal government, flag for the state, and native tribe also have their own flag. So for the native people, citizenship is also triple and flag is also. And the functioning of these, all the 159 tribal nation governments, they are not similar. They have different setup depending upon how it is written in their own constitution. Due to that, all the constitutions are not homogeneous. They are heterogeneous. There are certain dissimilarities. But I sum up some of the similarity, and the common similarity of these tribal nation government of the Native American tribes shall be briefly highlighted as given below. Okay, starting with jurisdiction membership. How far the tribal nation government of the Native American tribes have jurisdiction. Geographical jurisdiction of this tribal nation government of the Native American tribes, it extends to the land territory occupied by the native tribes, and it is known as Indian country. The jurisdiction of the tribal nation government extends to Indian country. Indian means native people, not people of India. And this Indian country is defined as the land which is in reservation and those land occupied by the native tribes outside the reservation. And these tribal nation governments, they are sovereign authority within the native tribe. And this tribal nation government, they usually classify their membership or citizenship on the basis of descendancy, residency, blood quantum, birth or through enrolled mother or enrolled father. As I've mentioned, some native tribes are matrilineal system, some are patrilineal system. Those who followed matrilineal system, membership is counted from enrolled mother, and those from patrilineal system, membership is counted from enrolled father. So the criteria for deciding membership or citizenship is also different among the different tribes. Like government of the Cherokee Nation of Oklahoma decide membership on the basis of descendancy. But Papaho Nation decides on the basis of Dawes Commission Roll of 1906. That means those people whose ancestors are not registered in this Dawes Commission Roll of 1906, their membership is denied. Then Unita Kori tribe of Utah decides on blood quantum. That means blood quantum means their membership should be divided if they have at least 1/2 native blood. Then Peyote and Shoshone tribes decide on the basis of 1/4 Peyote Shoshone blood. That means if at least 1/4 of the blood is from the tribe, then their membership is accepted. If not, it is rejected. Then Santa Clara Pueblo tribe decides membership from only enrolled father. And Onondaga and Seneca tribes membership only from enrolled mother. And with regard to this membership, some cases with regard to membership has been appealed to Supreme Court. But the Supreme Court of the United States of America, in its judgment, declared that whatever the tribal can decide on the basis of their custom and culture, that is final. And Supreme Court never changed decision of the tribal. So Supreme Court also respect the custom and culture of the tribe due to that what the native government has decided on the basis of its traditional custom, it is always upheld by the Supreme Court. Okay, with regard to the legislative power, most of the nation government adopts three organs of government: legislative, executive, and judiciary. But there is no strict separation of power like the federal government of the United States of America. In the Muskogee tribe, the Muskogee tribal nation government adopts legislative branch as National Council, which comprise of two houses: House of King, like the Senate of US, and House of Warriors, like the House of Representative of US. Then Seneca tribe adopts tribal council as legislative body, and Chesney River tribe adopts council as the legislative body. So many of the tribes, they base their constitution on traditional pattern. But all tribal governments, all tribal nation governments, in one way or the other, exercise legislative power in their respective jurisdiction. Then this tribal nation government can pass laws with regard to regulation of hunting and fishing on the reservation or Indian country for both tribal members and non-tribal members. And if it is within their jurisdiction, even non-native people, they are under this law. And tribes also have the authority to regulate their own economic activity, like to grant license, to tax, to zone. To zone means like demarcation of land, then establish business and develop resources through legislative act. Then this tribal nation government also can levy taxes through legislation like income tax, business tax, property tax, severance tax, sales tax, excise tax, and other taxes. Okay, moving on to the executive powers. The structure of executive is also different in different tribal nation government. Executive in the Seneca tribe by the president, who is assisted by clerk and other officers. In the Muskogee Nation, the executive branch consists of the principal chief, chiefs, who are elected for a term of 4 years by all other citizens above 18 years of age. And there is also a treasurer and national interpreter. The main responsibility of this executive branch is to execute legislated by the legislature. And after the Congress of United States has passed Indian Self-Determination Education Assistance Act in 1975, it enormously increased the executive powers of the tribal nation government. And these executive of the tribal nation government mainly execute works relating to health, education, economic development, housing facilities, land and natural resources, children and youth, language and food security of the native people. And now, after tribal nation government manage their own health care, that longevity of the tribal life increased by about 20 years. And this Native American tribal nation government also collected toll tax on vehicle plying in the territories in the highway, and it is a good source of income for them. Then another good source of income for them is casino. When I visited state in July this year for my field work, I traveled from Tulsa to Oklahoma City. Then in different places, toll tax collection gate of the native peoples is there. Then in that toll tax gate, if some coins are not dropped in the gate, the vehicle could not pass through. Whether it will be federal government vehicle or any vehicle, all vehicle plying in the highway in their area, they collected tax. It is a good source of income. And other than that, they also had their own casino. I visited one casino of the Cherokee tribe. Then this casino is also a good source of income for these people. Okay, moving on to the judicial powers. European colonizers and explorers regarded the Native American tribes as people without law and order. But contrary to their observation, these native tribes, they had their own stable laws and customs which regulated behavior, domestic relation, and their relationship with the tribes. Anglo-American and European law focused upon individuals, but law of the native people focused upon community. Native people, Native American tribes gave first priority to community, and they felt that individuals in community would be safe if community is safe. Due to that, land also belonged to the community. Land is never privatized, and land has been never privatized. On this very basis, different European powers and United States afterwards, they failed to deal accurately with the needs of the native tribes. So, in the concept of the native tribes, land belongs to the community, land can never be privatized, and land is a thing which cannot be simply sold and which cannot be simply passed on from one person to another person because it belongs to community. And as they get emphasized on this community, traditional custom law and customary law also focus on the native tribes. And the difference between Anglo-Europeans and the native people is that native people focus more on obligation and duties, but Anglo-European law focus more on individual rights. So they emphasize more on performance of duties than claiming for rights. That is the concept till now. And so far as functioning of this judiciary is concerned, all the tribal nation government, they have their own judiciary setup, they have their own law courts, but the judiciary setup of the tribal nation government are not same and are different. So these tribal courts are not uniform in structure, functioning, and the law which they apply. Some tribal governments have new courtrooms. One request which I would like to make, participant, please off your video. I find one participant always owning the video. Please off your video, participant. Please off your video and you can listen with offing your video. Okay. Like different native tribes, participant, please don't on your video. Owning video is not necessary for you. Please off your video, participants. So, different
all the
native tribes.
participants are requested to put off your video, please. Please turn off your camera.
Please put off your video, participant. Mr. Jangkhongam Mate, please put off your video. So different tribal nation government, they have their own courtroom bound with volumes of tribal laws and having capacity of establishing juvenile court and conservation court. But some other tribal government, they do not have such setup. And the court officer of the tribal comprised of judge, court reporter, a bailiff, tribal prosecutor, and police. Like in the Navajo tribe, there are 6 district courts, Supreme Court, and a police about 200 members. And most tribal judges are from Native American tribes or members of other tribes. Few of the judges are lawyers who got training from Native American Indian Court Judge Association. And the role and responsibility, status of the lawyers also vary in different tribal nation government. Some conduct their own bar examination, but some tribes, they depend and they follow the state legal norms. And some tribes do not want tribal code to be over legalistic, and they didn't want participation of non-tribals. And tribal nation government usually handle about 70 cases a year. And out of these, 70% of the cases are minor, 30% of the cases are civil. And this tribal court possesses both civil jurisdiction over the Native Americans and non-natives, but many tribal nation government prefer to adjudicate the cases only among the tribes. But by the Major Crimes Act of 1885 and Oliphant decision of the Supreme Court of the United States in 1978, the jurisdiction of this tribal code was restricted. Okay, the last part of the Native American finance. We know that any government cannot function without finance. So money is required to activate government. Likewise, these tribal nation government of the native tribes, they receive their funding directly from the federal government. And in any dealing of the native tribes with the federal government, state government is not involved at all. State government is not involved. They get direct funding. What some people in Mizoram, particularly in 6th schedule area, they say direct funding. Here in the United States, these native tribes, they get direct funding from the federal government. So in their dealing with the federal government, state government is not involved at all. State government is not involved at all. They deal directly with the federal government. And besides funding directly from the federal government, these Native American tribal government also can mobilize their own financial resources by regulating and by exercising license grant, tax zone, business. Then they also have the power of levying taxes in the form of income tax, business tax, property tax, severance tax, sales tax, excise tax, and other taxes. Then they also collect toll taxes from all those vehicles plying in their territory. Then they also get good income from casino, and they also extract natural resources and forest resources from their jurisdiction. So those are the powers, responsibility, and constitutional status of the native tribes. Now, moving on to constitutional status of indigenous people in India. As we know, the indigenous people are divided into two: indigenous people of mainland India or Adivasi, and indigenous people of Northeast India. And I will be dealing only with the indigenous people of Northeast. So these indigenous people of mainland India, their constitutional status has been incorporated in Article 244 Clause 1 and 275 Clause 1 of the Constitution of India. And their area, though they are tribal, it is known as scheduled area. But these tribals in undivided Assam, it was known as Assam at the time when Constitution was enforced. The status of tribals of undivided Assam or Northeast India, it has been incorporated in 6th schedule and in Article 244 Clause 2 and 275 Clause 1 of the Constitution of India. And the area of these occupied by these tribal under 6th schedule, it is known as tribal area. And in this 6th schedule, there are, up till now, there are 4 different forms of constitutional setup: regional council, autonomous district council, ADC, autonomous council, and territorial council. Originally, there were only 2 setups: regional council and Autonomous District Council ADC. But after amendment of the 6th schedule in 1995, Karbi Anglong ADC and North Kasar Hills ADC, they were upgraded to higher status, and 15 additional subjects have been incorporated to them in in paragraph 3A of the 6th schedule. And after that, by latest amendment of the 6th schedule in 2003, Bodoland Autonomous Council was incorporated in the 6th schedule with new name Bodoland Territorial Council, and 38 additional subjects have been accorded in paragraph 3B. Okay, what are the legislative power? Legislative power of Regional Council, ADC, Autonomous Council, and Territorial Council are incorporated in paragraphs 3, 10, 11, 12, 13 of the 6th schedule to the Constitution of India. And as I've mentioned, 15 additional subjects have been incorporated for Autonomous Council in paragraph A, and 38 additional subjects have been incorporated for Territorial Council in paragraph 3B. And on the basis of this power, lawmaking powers have been exercised by the different councils under 6th schedule. Then in paragraph 10, power has been given to ADC for control of money lending. Then in paragraph 11, it is mentioned that all laws, rules, and regulations enacted by ADC shall be assented by the governor, and after that it shall be published in Gazette of the State, and it will come into force. Then paragraph 13 incorporates about estimated receipt and expenditure of ADC. So those are the legislative powers. And executive powers. The main responsibility of the executive branch of government is to execute the laws made by the legislature and to activate the main functioning of the government authority. So executive powers of the Regional Council, ADC, Autonomous Council, and Territorial Council are enshrined in paragraph 6, paragraph 8, paragraph 9 of 6th schedule to the Constitution of India. Paragraph 6, subparagraph 1 of the 6th schedule enshrines that the ADC may establish, construct, or manage primary school, dispensary, market, cattle pounds, ferries, fishery, roads, road transport, waterway in the district, and may, with the previous approval of the governor, may make regulation for control of and for primary education in the district, and language are to be used for imparting education. And in this regard, ADC of Mizoram now look after up to middle school. Then Autonomous Council in Assam, they look after up to higher secondary, but now up to college. Then BTC look after up to college. Then in paragraph 9, there is mention of the role of governor. Like in the 6th schedule area, in ADC area, if there are some extraction of minerals, that should be equally shared by the state and the ADC. And if they cannot arrive at appropriate decision, governor of the state shall take decision in his discretion, and that should be final. So those are the executive powers. Judicial powers. Judicial powers of the council, ADC, Autonomous Council, and Territorial Council are enshrined in paragraph 4 and 5 of the 6th schedule to the Constitution of India. And in this paragraph 4, the 6th schedule empower Regional Council and District Council to constitute village code and district code. Then in paragraph 5, mention has been made about the applicability of Code of Civil Procedure 1908 and Code of Criminal Procedure 1898 in Regional Council and District Council. And on the basis of this provision, in many ADC, this District Council Code, Intermediate District Council Code, and Village Code are functioning. And on the basis of, these codes are functioning on the basis of customary laws and convention. But in this ADC code, the ADC code can take up cases only between the tribals. If non-tribals are involved, it cannot be taken up by the ADC code. Then financial power. With regard to finance, it is mentioned in paragraph 7 and 13 of the 6th schedule and in Article 2751 of the Constitution of India. In Article 275 clause 1, it is mentioned that the council may get funding from the Consolidated Fund of India through the state. So any funding of the district council cannot go directly to ADC. It has to go, everything should be processed through the difference between the Native American tribal nation government and ADC under 6th schedule, which I'll come afterwards also, is that in America, the native tribes bypass the state and deal directly with federal government, but that is not the case in India. The dealing of the central government and ADC, it is only through the state government. That's why there is no possibility of direct funding for ADC in India. It is impossible. Okay, we'll now move on to the comparative analysis. As has been mentioned, detailed provisions of Native American tribes are not incorporated and cannot be incorporated in detail in the Constitution of USA. So, provisions of these native tribes, some mentions are there in Section 8, Article 1, then Section 2, Article 1, Amendment 5, Amendment 10, and Amendment 14. But the provision is not there. And due to this absence of detailed provision, the functioning and status of these native tribes totally depend upon legislation of the Congress. And due to this, the Congress had enacted draconian laws towards the Native American tribes, and the Native American tribes face discrimination and ill treatment for about 2 centuries. So some notorious laws like Remover Act of 1830, then termination policy, in such a way, draconian laws had been enacted against these Native American tribal nation government. But with the case of this ADC under the 6th schedule, after enforcement of the Constitution of India, there is no such discrimination from the central government of India. And due to these different draconian laws and discrimination, reservation and nation government could function properly for about 2 centuries. And this reservation and tribal nation government, in the strict sense of the term, could function properly only after lenient policy, only after revival policy had been adopted by President Nixon in the late 60s. Okay, now comparative analysis of the two systems in legislative power. So with regard to this legislative power of the tribal nation government and ADC under the 6th schedule, they are not similar, they are not same. Like tribal nation government of the native tribes, they can pass some law with regard to hunting, fishing in the reservation, which should also cover the non-native tribes. Then the regulation passed by the tribal legislature of the native tribe can also restrict the movement of non-native tribes. But in the case of ADC, Regional Council, and other council, such powers of these Native American tribal governments are not possessed at all by ADC and other council under the 6th schedule in India. And so far as the setup is concerned, like different tribal nation government, they have their own legislature, and the structure and functioning of their legislature depend upon how the provision is incorporated in their tribal constitution. But in case of the ADC and other regional council or autonomous council or territorial council under the 6th schedule, the setup is all similar because it is based on upon the provision of 6th schedule to the constitution of it. But in the case of Native American tribal government, as they followed their constitution, the setup, the responsibility, power, and function, they are not uniform. And the native tribes, they can also tax, they can also extract natural resources, forest resources, and mineral resources in their jurisdiction through legislation. But in the case of ADC, such powers are not given. ADCs are given power to legislate and control forest. But in the case of forest also, reserve forest is again controlled by the state government. But in the case of the native tribes, whether it be reserve or unreserved, if it is not sanctuary or national sanctuary, it is in the hands of the government. And with regard to this Native American government, the provision which are not enshrined in the federal government can be claimed by the tribal nation government. Having said that, the tribal nation government can claim it, but if the provision is not clearly incorporated in the tribal constitution, they may not, they cannot, because whatever they have incorporated and enshrined in the tribal constitution, which is not covered by the federal government, they can claim it, but it is not properly incorporated in the tribal constitution, that they cannot claim it. So with regard to this lawmaking, Native American tribal nation government, they have wider scope, responsibility, and powers ADCs and other council under the 6th schedule in India. Okay, executive. The setup of executive in different tribal nation government, it is different. As I've said, because it depends upon how they laid down, they incorporated the function and responsibility of the executive powers in their own tribal nation government. And after the Congress has passed Indian Self-Determination and Education Assistance Act in 1975, the responsibility of the tribal nation increased with regard to this executive power. And this tribal nation government can levy taxes through legislation like income tax, business tax, property tax, sovereign tax, sales tax, excise tax, and other taxes. And different tribes, they also tax even non-tribals who run business in the reservation, like Blackfeet, Crow, Navajo, and Jikara tribes collects even severance tax on the basis of legislative acts. So all these constitutional status and responsibility for collection of taxes are not given to ADCs and other council under the 6th schedule in India. And different tribal nation government, they take a program for reforming alcoholic addicts in their respective jurisdiction. Then They also have their own system of zoning code. That means land revenue system. Then tribal nations also have their own system of conservation and preservation of environment. And this executive of the tribal nation government mainly execute works relating to health, education, economic development, housing facilities, land and natural resources, children and youth, language, road construction, and food security of the native people. And this tribal nation government also does everything it can for protection of water, natural resources, land, and environment of the tribal people. So the tribal nation government does everything for social and economic development of the tribal people. And as I've mentioned, they also collect toll tax for all vehicles plying in their area in the highway. And so far as the ADC and other councils under the 6th schedule are concerned, the ADC and other councils, they have the power to manage primary school, dispensary, markets, cater pounds, ferries, fishery, roads, road transport, and waterway in the 6th schedule area. And they also have the power over land revenue and to impose various types of taxes in paragraph 8 of the 6th schedule. But if the functioning powers and responsibility of tribal nation government of the Native American tribes and ADC and other councils under the 6th schedule, it seems the Native American tribes, they have more powers and responsibility, and they are more trustworthy, they are more efficient in their work, in my assessment. So in such a way, with regard to this executive power also, the Native American government, they have more powers and responsibility, they are more trustworthy, they are more efficient, and they do things exactly and correctly compared to different the 6th schedule area. They do not regard their tribal nation government as money-making machinery. Most of the tribal nation government, they do the work really and efficiently. And some tribal nation government also, besides the funding that they get normally from the federal government, they also get additional funding with regard to health services and others. And likewise, ADC under 6th schedule also get some funding, additional funding from the central government, like Boulder Area Development Program, different centrally sponsored programs like Boulder Area Grant Fund, BRGF, the Non-Lobsaber Central Pool of Resources. And with regard to these Native American tribes, the tribal nation government of the Native American tribe is being supervised by one agency, Bureau of Indian Affairs, IA. And the IA is a sub-department under Department of Interior. And the BIA and Interior Department directly looks after the affairs and administration of this Native American administration. And there is no involvement of the state government. But with regard to this ADC and other council under the 6th schedule, one thing that we have to know is that this ADC and other council under the 6th schedule, they are being supervised by Ministry of Home Affairs. And other than Ministry of Home Affairs, which get direction from the central government, in every state there is Tribal Affairs Department, and in District Council and Minority Affairs, and in some states, Tribal Area Development Program, in such a way, in every state, the 6th schedule administration is concerned, state cannot be bypassed, everything goes through the state government. Then with regard to this judicial power, the judicial power or judicial setup of both Native American tribal nation government and the 6th schedule are similar. That means both are based on customary law, convention, and traditional practices. But with regard to these Native American tribes, as I've mentioned, detailed provision is not provided in the Constitution. And as detailed provision is not provided in the Constitution, the functioning of court and judicial system to some extent depends upon how it is incorporated in their own tribal constitution. So the judicial setup of different tribal nation government of the Native American tribes are not similar, because it is implemented on the basis of the provision provided in their respective constitution. But in case of 6th schedule, ADC and other councils, it is all uniform. Why? Because it is set up and it is enforced on the basis of the provision provided in paragraph 4 and 5 of the 6th schedule to the Constitution of India. And like the legislative and judicial executive power, with regard to these judicial powers also, judicial setup of the tribal nation government, they have wider scope and responsibilities than ADCs and other council under the 6th schedule provision. Okay, financial powers, comparison of the financial power. As I've mentioned, the tribal nation government, they get direct funding from the federal government. But ADC and other council under the 6th schedule, they do not get direct funding. Everything goes to the state, because it is clearly mentioned in Article 275, Clause 1. Now, direct funding is claimed by some ADC leaders of Mizoram if it is to be successful. Of course, the parliament amend schedule and amend Article 275, Clause 1, it is possible. Having said that, the parliament can amend it, the parliament may not amend it. So it is next to impossible. So far as direct funding in ADC area of Northeast is concerned, direct funding may not be amended by the parliament, because provision is there, provision of direct funding is there only for the state and union territory, but not for ADC. Now, in Mizoram and Tripura, ADCs exercise around 18 subjects. And in Meghalaya, ADC exercise around 13 subjects. And in addition to the original 18 subjects accorded to the ADC, in Karbi Anglong and NC Hills, additional 15 subjects are given to the two territorial councils in paragraph 3A. And including these additional 15 subjects, these two territorial councils now exercise more than 30 subjects, maybe around 33, 34 subjects. Then to this territorial council, Bodoland Territorial Council, 38 additional subjects are given to it by paragraph 3B of the 6th schedule. So if we plus with the original around 18 subjects, these Bodoland Territorial Council exercise almost 50 subjects, but they are also not direct funding. So when these almost 50 subjects enjoying territorial council and around 35 subjects enjoying autonomous councils are not directly funded, will the parliament amend the 6th schedule and provide direct funding for in Meghalaya and Mizoram? Yeah, parliament can do it, but parliament is not likely to do it because it is there in the constitutional provision. So with regard to these financial powers also, as I've said, Native American tribal nation government, they get direct funding, but ADC under 6th schedule, they do not get direct funding. Then with regard to mobilization of resources also, these Native American tribal nation government, they, besides direct funding from the central government, they have their own power mobilizing resources, like they control forests, they control mineral resources, they control environment, within the jurisdiction, then they can levy different types of taxes. But all those powers are not accorded to ADC under the sixth schedule. So with regard to this financial power also, Native American tribal nation government, they are in more advantageous position because they get direct funding from the central government. But ADC under sixth schedule, it is like a daydreaming game. Then with regard to judicial interpretation, okay, this is the last comparison part. So judicial interpretation means it is not relevant in the Constitution of India, but it is much relevant in the Constitution of United States of America. Why? As I've mentioned, Constitution of United States of America is not a detailed constitution. It is a small booklet. Due to that, every functioning and every process of the Constitution of the United States of America, most of the time, it depends upon interpretation of the Supreme Court of the United States of America. And with regard to this term Supreme Court also, the difference in the constitutional system USA is that in India, Supreme Court is used only for the national court. We have only one Supreme Court. When we mean Supreme Court, it means Supreme Court of India. But in United States, that is different. The term Supreme Court is used even by High Court, even by the Native American judicial system. In India, when we call Supreme Court, that is Supreme Court. Then every court in every court in the state, it is High Court. Then in metro cities, Metropolitan Court and Chief Judicial Magistrate Court. But in United States, there is Supreme Court of the United States of America, Supreme Court of the State of New York, Supreme Court of the State of Kentucky, Supreme Court of the State of Oklahoma, and even the Native American tribe, they have their own Supreme Court. So with regard to the constitutional structure of the United States of America, if Supreme Court is mentioned, it should always be mentioned Supreme Court of USA. If not, it may be Supreme Court of some state or Supreme Court of the native tribal government also. Due to that, this judicial interpretation of Supreme Court of USA is very, very significant for constitutional development of USA. Because as I've mentioned, as detailed provisions are not written in black and white. Most of the time, any decision, any constitutional question is being finalized by interpretation of the Supreme Court. Likewise, with regard to this functioning of the Native American tribal government also, this interpretation of the Supreme Court is very, very significant. But with regard to the functioning of like sixth schedule, judicial interpretation of the Supreme Court is not that significant because detailed provision is provided in the sixth schedule provision. Even if some case has been reported from the ADC to High Court of the state and Supreme Court, it is more political in nature and constitutional. It is not serious, but the case is different in United States of America. Then, what judgment of the Supreme Court of the United States is so significant for the Native Americans? I think many students of political science may be familiar with Chief Justice John Mercer. Chief Justice John Mercer, he was the one who upheld judiciary of USA, and he was the one who upheld the Constitution and the federal spirit of the Constitution of the United States of America. So one critical case was taken up by the Supreme Court in 1831, and there it was a case between Cherokee tribe of the Native people and federal government of the United States of America. Then in this case, what was the judgment delivered by Chief Justice John Mercer? And this judgment happened to be a constitutional practice for the tribe afterward also. So Chief Justice John Marshall pronounced his Cherokee case in 1831 that the Cherokees were not a foreign state within the meaning of Constitution of the United States. They were neither citizens of a foreign nation nor state citizens, but they were domestic dependent nation. So the native tribes are domestic dependent nation. Then he found that Cherokee tribe was a ward and United States was a guardian. That means father and son. United States was a father and Cherokee tribe was a son. This significant judicial interpretation was affirmed as the guiding principle with regard to the constitutional and legal status of all the Native American tribes in the days to come. So, what did he mean to say by a ward and a guardian? Cherokee tribe and other Native American tribes, they are dependent nations who depended upon the United States of America. So it is the responsibility of the federal government to look after them. And since then, the native tribes are directly funded by the federal government. Federal government has done its responsibility as a constitutional guardian towards its wards. Because of that, tribes are directly looked after by the federal government. Justice Marshall also declared in the Woolchester versus Georgia case that the relationship between Cherokee and Georgia was a nation claiming protection of more powerful nation and protectorate relationship, but the weaker nation still retains the right of self-government. So, Georgia state, all those Cherokee tribes in Georgia, they were tried to be controlled and legislated by the Georgia state government. Then Cherokee tribe, they engaged one attorney. That attorney stood for the Cherokee tribe in the Supreme Court of United States. And in that judgment, the same Chief Justice Marshall, he said that Cherokee tribe was a protectorate nation. For example, if some nation has been threatened, that nation sought the protection of another powerful nation. So, Cherokee nation sought the protection of federal government. Federal government has to provide all what Cherokee people needs. So there is no scope for interference of the state government of Georgia. And after that, any steps, any attempt by the state government to control and administer the Native American tribes stop. So Native tribes are under direct rule, control of the federal government from that onwards. And these Native tribes were continuously subjugated, discriminated from time to time, like by the Removal Act of 1830. This Removal Act of 1830 was enacted during the presidency of Andrew Jackson. And by this Removal Act, Native American tribes from their inhabited territories, they were forced to move to the present state of Oklahoma. And many Native tribes, they were forced to travel more than 500 miles distance, and many people died on the way. In fact, this is gross violation of human rights, which could be compared to Nazis' concentration camp during the Second World War. Then in such a way, the land, property, and rights of the native tribes were discriminated. Then after that, there was another draconian act, General Allotment Act of 1887, which was also known as Davis Act of 1887. By this General Allotment Act of 1887 also, many lands of native tribes were taken by the federal government and the state government. Then, the Indian Citizenship of 1924, federal citizenship was given to the native people, And Indian Reorganization Act of 1934 did some reform for the native tribes. But all those reforms were destroyed again by this Public Law 280 and culmination era. So in such a way, these native tribes, they were subjugated, discriminated from time to time. But after President Johnson and President Nixon followed revival policy from the 60s and early 70s only, the native tribes could be revived. The Native American tribal nation government could function again. Some reservation could function again. But many harms, many irreparable harms had already been done to the native tribes. And so far as the 6th schedule area is concerned, there was no much critical judicial case, except the bifurcation of United Khasis and Tia Hills District Council. In 1964, United Khasis and Tia Hills District Council was bifurcated into 2 districts without parliament enactment. And as it was done by governor without being enacted by parliament, Edwinson Barre, he filed case in the Supreme Court, and that case was known as Edwinson Barre versus the state of versus India. And in that case, majority of the Supreme Court said that governor has the power. But one important dissenting judgment was given by Justice Muhammad Hidayatullah, who became the Vice President of India afterwards. So Justice Muhammad Hidayatullah mentioned that as this power in paragraph 1 relates with paragraph 20, it cannot be done without parliament enactment. And the constitutional debates carried on, but that was solved by Northeastern Area Reorganization Act of 1971. In Northeastern Area Reorganization Act of 1971, one new clause was added. By that, it is mentioned that this power of the governor in paragraph 1 relates with paragraph 20. So it cannot be done without amendment. After that problem has been solved. Okay, now I'll come to the concluding remark. We'll come to the conclusion. Tribal nation governments of the Native American tribes and ADC and other council under 6th schedule have been accorded different constitutional status by Constitution of the United States and Constitution of India respectively. Detailed provision of tribal nation government have not been incorporated, but only precise guidelines have been inserted where tribal nation government have been established as a result of treaties signed between federal government and native tribes, but detailed guidelines have been incorporated for ADC and other council under the 6th schedule to the Constitution of India. As a result of 390 treaties signed by native tribes with federal government, more than 300 reservations were established and 159 tribal nation government have been functioning in 27 states across United States till today. So now native tribes, they have some reservations and there are 159 tribal nation government, but under 6th schedule to the Constitution of India, there are, so to say, if we use the term of US Constitution, 10 tribal nation government. So to say, 7 ADC, 2 autonomous council, and 1 territorial council. Though the constitutional structure of tribal nation government of the Native American tribes and ADC and other council and 6th schedule are different, their functioning, responsibility, aims are more or less the same. Both are based on the pattern of 3 organs of government, namely legislative, executive, and judiciary. And one thing that I need to mention is that from the functioning of this Native American tribal government, father of the Constitution of India, Dr. B.R. Ambedkar, copied the system of this Native American tribal nation government, and it has been copied and 6th schedule is created in the Constitution of India. So this Native American 6th schedule to the Constitution of India, it is copied from the system of these Native American tribes. I think I failed to mention that. And so far as the ADC and other councils under 6 schedules are concerned, their powers, status, responsibilities are given in detail in the Constitution, but detailed provisions are not provided for different tribal nation government in the Constitution of USA. So these tribal nation government, they have their own constitution. Their functioning depends upon how the provisions are incorporated in their respective constitution. And these tribal nation government have their own flag, their own citizenship, and their own constitution. They have wider scope, wider legislative, executive, judicial, and financial powers. But these ADC and other council under they don't have different citizenship, they don't have different constitution, they don't have different flag. They share the flag of India, they share the constitution of India, they share the citizenship of India, but they have legislative, executive, and judicial powers. And when, so far as the funding is also concerned, these Native American tribal government, they are funded by ADC and other council under the 6th schedule, they are funded directly. They get their funding and everything which are processed to them by the center only through the state government. That is also the other differences between the Native American tribal government and the 6th schedule. So in this modern world, indigenous people in many countries of the world are marginalized, discriminated, they are tortured, there are lots of human rights violations, but constitution of the two largest democracies in the world, USA and India, at least accorded some constitutional safeguards for indigenous people in their respective country. Having said that, constitutional provisions have been incorporated for the indigenous people. The term indigenous is not yet recognized in constitution and legal system of both countries. So indigenous is a popular political term, but it is not yet a constitutional or legal term. So the constitutional and legal term for these indigenous people still is tribe and tribal. And United Nations in its UNDRIP declaration has already declared indigenous, but the term is not yet accorded by any constitution of the world. Whatever it is, so some have been provided for safeguard of these indigenous people in India and America. As far as these indigenous people of America and India are concerned, as I've mentioned, indigenous people of United States of America, they have more privilege, wider scope, and better facilities than the constitutional provision of indigenous people in India. Okay, with this, let me conclude my lecture, and now I will hand over the time to our moderator.
Okay. Thank you very much, Professor, for the insightful and refreshing lecture covering the different dimensions, the executive, the legislative, the judicial, and even the financial autonomy or the powers enjoyed by both the Native Americans or the Red Indians in the USA under the Constitution of USA and the tribal or the indigenous people in India who were given autonomous powers under the 6th schedule in the form of autonomous governments. So there are a few questions that are dropped in the chat box. Professor, sir, can you see the questions in the chat box, or shall I read them out for you?
You bet.
Some of the questions you have already addressed in the lecture, but for example, like the discrimination faced by the Native Americans, like you have said about the Removal Act of in USA, where the Red Indians suffered a lot. But we may know about the present situation also. Do they still face some kind of discrimination, whether in the social or economic spheres, or are there any kind of independent movements by the Native Americans present today or in the past also? And so I will give you the freedom to pick the questions, any of the questions, so that we may save time. So you can address the questions one by one and skip the unnecessary ones if you feel.
Yeah. There are many other draconian laws also which I have not mentioned due to limited time. And this Remover Act was the worst. This Remover Act was enacted during the presidency of Andrew Jackson. And even when it was legislated in Congress, many, they were against it because it is against democracy. Why is this type of draconian law should be passed? But the law was adopted with majority of 5 members only. Then, as I've said, some native people, they travel more than 500 miles. Many people died on the way. Then they were forcibly moved out from their traditional land, ancestral land, and they live with him. And even after that, there was Public Law 280 enforced in the 50s, then Termination Act. And by this Termination Act, the tribal status of about 100 tribes were terminated. They were no longer recognized as tribes after that. But so many irreparable harms had already been done. Then land of the territories of the native tribes were occupied one after another. And now the native tribes constitute only 2% of the population of USA. Only 2% of the population of USA. Then with regard to the population ratio, the blacks or African Americans, they constitute 15% of the population. Then Latino, Spanish speaking group, they constitute about 15% of the population. Then Asian Americans, immigrant from Asian continent, whether it be Chinese from India, Bangladesh, Pakistan, and all, they are all grouped together as Asian Americans. They constitute about 5% of the population. So Native American, even now it is just 2% of the population, and they occupy about 2% of the territory of you. Imagine it. Earlier, the whole territory of America was under Native Americans, but now they control only 2%, occupied only 2% of the territory, and population ratio is also only 2%. So for just 2% population, there is no chance for independence movement or armed struggle. And they didn't do also. But they fought many legal battles now. They didn't fight with weapons and armaments, but they are now fighting with many legal weapons. They are fighting legal weapons, and they won many cases also now. Like, let me mention one Black Hills, which is known as Paha Sapa. So, because of that Remover Act, the native tribes were forcibly removed from that Paha Sapa. Because from Paha Sapa, Black Hills, gold was discovered. After the discovery of gold, the native tribes were forcibly removed. Then the native tribes filed a case against federal government of United States of America, and that case took about 60 years. Then after 60 years, judgment was delivered by the Supreme Court of USA in early 1980s. And in that judgment, the Supreme Court ordered that $300 million should be given to the native tribe for forcibly occupying their ancestral land. And the native tribe is not yet accepting that. Case is still going on. Likewise, many other cases also. And in such a way, the native tribe now use legal means, use legal tools for fighting their rights and for fighting their privileges. And now there is no discrimination anymore. Many safeguards have been provided to the native tribes, but I have said it is already too late. Many irreparable harms had already been done by these draconian laws. And now, like we got tribal scholarship in India, for these Native American tribes, there is also separate scholarship to continue their higher education if they are a native tribe. But even in this scholarship also, I came to know from one source that many non-native, they applied this scholarship with bogus certificate. And it is said that 1/3 of the recipients of native scholarships, they are not native people. And some legal cases is also pending in the court. Now, every possible efforts have been given for protection of these native people. And in every respect, native people have been protected and safeguards have been provided. And due to that, it is said that people from other race, they want to marry the native girls so that they may be free from certain concession. This has been said when I went to Oklahoma for field work also. So far as the native tribes are concerned, the federal government has now every possible effort to protect them, to safeguard them, and to provide them with all the necessary requirements. And on the other hand, native tribes also fight their rights with legal weapons, and they tried every possible efforts to revive. But now, more than 90% of the native population, they no longer speak their dialect or native language. That is the status. So with regard to this, now it can be said that better late than never. Federal government has done every possible effort to safeguard and protect the native tribes, but I can say that many irreparable harms have already been done. I cannot locate the chat box, Dika. You better read out the question. I cannot locate the chat box.
So, do the Native Americans think about? Do the Native Americans think government reservation is necessary or not? If yes, how does the government deal about reservation for them? So, do they enjoy reservation? That is the main question. And another is, are the Native Americans satisfied with their status, their present status and position in the USA? Are the Native Americans satisfied with their status in the USA? And another question is, since there is no detailed mention of Native Americans in the Constitution of USA, how far do you think they are culturally safe as a minority? So since there are no distinct provisions in the US Constitution, are they culturally safe as a minority? Because you just mentioned the statistics of their being their minority. So, and moreover, if tribes, okay, you can answer up to that by now. And if we have time, I will read out other questions for you.
Okay. I think I've already answered the first question. Reservation means educational reservation or job reservation. What? Like reservation means earlier when treaties had been signed by the federal government with native tribes, some settlements of the native tribes have been protected, which were called reservation. And some of the reservations still function. And along with those who are in this reservation, they have their own government, which I mentioned, tribal government. But particularly in Oklahoma State, reservation no longer function, but tribal nation government still function. But some tribes, they still have both reservation and tribal nation government, and some tribes, they only have tribal nation government. And with regard to this, like reservation in the sense of Constitution of India, maybe educational reservation, scholarship for the students, it is maintained, I think I just mentioned. So
Sir,
some form of reservation, yeah, some form of reservation is there. Yeah, okay.
Rather than educational reservation, what about political reservation, like seats reserved in the legislative assemblies and other types of reservation, like particularly political? What about that? Are there any reservations for minorities?
There is, up till now, there is no reservation like we have in India. And with regard to the state constitution, I will be meeting one faculty member of Department of Political Science who is expert in the state constitution. I think I may be able to know detail about the reservation system from him. But so far as my understanding is concerned, what we call this political reservation, it is not there. Maybe if the constituency or the area is occupied by Latino member will be elected. If it is dominated area of the Asian American will be elected. And if it is dominated area of the black Americans will be elected. But there is no such official reservation like we have in India. Of course, like as I've mentioned, for reservation like awarding scholarship or providing scholarship for the native tribes and for job opportunities, those are there, not political reservation. And with regard to the question, are they satisfied? Yeah, I have already mentioned that they have faced discrimination for more than 2 centuries. And since the revival policy of President Nixon and President Johnson from the late 60s and early 70s, tribal nation government which could not function for many years, reservation which could not function properly for many years, began to function again. There are now 159 tribal nation governments, and the best option and the best opportunity is provided to them by the federal government. So they are satisfied with it. And even if they are not satisfied with it, there is no other option. But as I've said, in aspect and areas where they are not satisfied, they use legal weapons. They use legal weapons for fighting for their rights. And yeah, with regard to the constitutional status, I mentioned that there is Constitution of USA, Federal Constitution. There is Constitution of State, and there is Constitution of Native American Tribal Government. Though detail is not there in the Federal Constitution, they have their own tribal constitution. If the provisions are provided clearly in their own tribal constitution, it is safe. So it does not mean that though detail is not there in the Constitution of USA, they will keep on discriminating, they will be punished, they will be discriminated. It is not like that. Though detail is not provided in the federal constitution, they have their own tribal constitution and their functioning depends upon the tribal constitution. So their own tribal constitution is also more or less the same as inclusion in the federal constitution. In such a way, we can say that they are safe. And with regard to culture, yeah, of course, they have been assimilated. Different assimilation techniques and different discrimination techniques had been applied upon them for more than 2 centuries. Due to that, impact is usually there. So as I've mentioned, more than 90% of the population no longer speak their language. When I interview one lady who worked in 5 Civilized Nations Museum in Oklahoma, I had wide-ranging discussion with her. And when I mentioned her about her understanding of the native language, she said that from the time of my grandfather, even my grandfather was forcibly kept in boarding school. From the time of my grandfather, we no longer use native language in the family. Some of my grandfather and grandmother, they still speak, but many of the younger generation, we can no longer speak. This is what she told me. But from different levels, whether it be from the federal government and also from the tribal nation government, different steps have been taken up for protection of their culture, custom, and tradition. And the federal government is also helpful and constructive in this regard. As I've mentioned earlier, like no more discrimination termination policy, no more removal act has been implemented now. The federal government is fully cooperative for the cause of these native tribes. And I think some positive steps take place. And even now, in the cabinet of Biden, one Native American lady is there as important secretary, which never takes place. And so far as culture is concerned, let's hope that different states have been taken up in order that they can get good constitutional safeguard and good protection. Okay, we can move on to the next question, Tika.
Oh, sir, this question is from Rautang Liana. He asked that given the Native Americans have the highest poverty rate of any major racial group in the US, with 1 in 4 people living below the poverty line, is it possible that the US federal government policies and programs, as well as local governments, the tribal nation governments themselves, doing enough to uplift them? So, what do you think? You have been given financial autonomy, they have enjoyed several types of autonomy, but their poverty rate is the highest among all nations. So, what is your justification?
See, I've mentioned time and again that they have been discriminated for more than 2 centuries. So the real concern and steps for the native tribes began to be taken place only since early 70s. Now, the federal government is cooperative. Different steps have been taken up. But as many irreparable harms had already been done upon them, things cannot go fast. But from the federal government, every possible efforts have been given and every possible efforts have been tried to protect them and to safeguard them. And of the native tribe, from Choctaw tribe, he took me in his own car, free of cost, for 3 days during my field work. And when I asked him about the system functioning, the step taken by the federal government, he said he is satisfied. The steps taken by the federal government now, more than these, things could not be done. So even the tribal people are satisfied. But from the tribal nation government and from the tribe also, they have to mobilize among themselves. They have to motivate among themselves so that they may be able to utilize the government fundings and the government provisions properly. For example, even in different states of Northeast India, we see there are misutilization of government funding and misutilization of many provision and facilities. So if there are misutilization of funds, or if the people are not aware enough, it may not be properly implemented. So far as the native people are concerned, the Native American tribal government and the federal government, they tried their best possible efforts. And in this regard, more awareness and more motivation also should be created, inculcated in the minds of the people, and they are moving towards that direction. And let's hope that things will move in the better way. Even with regard to this research also, more emphasis has been given upon the native tribes now. Let's hope some positive development will take place. But as I've said, overnight change is not possible. As many irreparable harm has been done for more than 2 centuries, due to that, some steps, some gaps are there.
Okay, sir. One last question from my side. We are talking about the U.S. Native Americans and their autonomy in comparison with Northeast Indians. And so at the end of the day, we have to think of India, our Northeast, our autonomy. And so you said that Native Americans enjoy financial autonomy, direct funding from the central government. But whereas in India, the autonomous governments under 6th schedule, they are fighting for this direct funding. But you yourself, you are a staunch critic of this politics of direct funding. But at the same time, if you are given power, legislative, executive, judicial power, but enjoy no financial autonomy, then you will not really enjoy power. So do you think that this amendment of 275 clause 1 article of the Indian Constitution can be amended, and what do you think of these present demands for direct funding? What is the complication? What is the possibility? So if you can briefly answer that, what are the complications? What makes you say that it is next to impossible? So we would like to hear that.
Yeah, let me go a little bit to the historical background. With regard to this issue of direct funding, 6th schedule has been amended 10 times up till now. In 1954, in 1957, in 1969, in 1954, 1957, then 1964, 1969, then 1971, 1974, then in 1984, 1995, then 2003, and one amendment that creation of bifurcation of United Khasis and Tehil District Council, it was done without parliament amendment. So the latest amendment up till now is 2003. And after upgradation of these North Kasar Hills and Karbi Anglong to Territorial Council, some ADC, particularly ADC of Mizoram, they raised the demand for higher political status. And that higher political status, they upgraded themselves to direct funding in the 2000. And with regard to these 6th schedule amendments, process has been taken up by the central government, Ministry of Home Affairs, through different study team and core team. Some of the study team and core team, which has been set up by the central government for amendment of the 6th schedule. The first one is National Commission to Review the Working of the Constitution, 2001, under the chairmanship of P.S. Sangma. And the second was Administrative Reform Commission, 2005, under the chairmanship of Virapa Moili. And next was Planning for the 6th Schedule Areas, 2007. And the next and the latest was Cole's team to study on functioning of local government in Northeastern region with special reference to ADC and Regional Council 2009. In this Cole team to study on functioning of local government in Northeastern region in 2009, Professor David Shimley was the coordinator, and I was one among the 14 members. So we did survey on the functioning of local government, and our finding was incorporated and submitted to Ministry of Home Affairs in June 2009 by our coordinator, Professor David Shimley. And all these findings of the core team and research have been incorporated in the ongoing 6th Schedule amendment process. In 2011, there was an amendment, Constitution 115 Amendment Bill, but it lapsed. And after that, the present bill is in the process, Constitution 125th Amendment Bill 2019. Then for this Constitution 125th Amendment Bill 2019, Vice President of India and Chairman of the Rajya Sabha, Sri Venkat Naidu, he set up one parliamentary team. And in that parliamentary team, there were more than 40 members, which comprise of members of Lok Sabha and Rajya Sabha and 7 officials. And Anand Sharma was chairman of that committee. And Anand Sharma committee did survey about this bill and submitted its report to the Home Ministry. And in its report to the Ministry of Home Affairs about how this bill should be taken up, in the report of the Anand Sharma committee, amendment of Article 275 is not included. Then some of the provisions which are included are, there shall be State Finance Commission. State Finance Commission should be set up in all the states which have 6th schedule. And that State Finance Commission should streamline the funds which come from the center to ADC, and funds of the ADC should be channelized through that State Finance Commission. That means even if, and as per the recommendation and proposal of Anand Sharma committee, more powers, more subjects, responsibility, and more funding will be provided to ADC. But it should go only through the state government, through State Finance Commission. Of course, if the present bill is tabled and it is enacted, it is likely that ADC will have more powers, more responsibility, more funding, and more subjects. But it is not likely to be direct funding, because the process will still go through government. And there is no proposal by the Parliamentary Committee for amendment of Article 2751. So if there is no proposal and if there is no amendment of this Article 2751, whatever powers and responsibility handed over to ADC, it will only go through the state government, and it is unlikely that there will be direct funding. Then one thing which should be added is that, so in the Parliamentary Committee report, it is recommended that those ADC in Tripura, Meghalaya, and Assam, they should be called Autonomous Territorial Council. Why? Because in Tripura, TTADC covers 8 administrative districts. Then in Meghalaya, Khasi Hills Autonomous District Council cover about 4 administrative districts. Then Garo Hills cover about 5 administrative districts. Then Jantia Hills also cover about 2 administrative districts. Same is with that Karbi Anglong and NC Hills. So they should be entitled and their designation should be changed as Autonomous Territorial Council. But with the case in Mizoram,
Okay.
the finding and creation of the parliamentary committee mentioned that these in Mizoram, for example, in Longklai district, within one administrative district, there are 2 ADC. Then in Saya district, there is 1 ADC. But in the case of other states, in 1 ADC, there are more than 2-3 administrative districts. But in the case of Mizoram, in 1 ADC, there are 2 or 1 ADC. So the term territorial council is not applicable for Mizoram. And that is the association of the Parliamentary Standing Committee. So on the basis of the recommendation of this Parliamentary Committee, it is unlikely that what they call direct funding will be possible, because up till now, direct funding is accorded only for state and union territory. Of course, ADC may get better fund, more subjects, higher political status, and more power, but it is unlikely that it will be direct funding, because all the process seems to be continued to go through the state government. And one thing that should be added is that if almost 50 subjects enjoying council like Bodoland Territorial Council and about 35 subjects enjoying council like Karbi Anglong and North Kachar Hills are not accorded direct funding, will Parliament enact law specifically for ADC of Mizoram which enjoy only about 18 subjects to be directly funding? So it depends upon the will of the Parliament. If the Parliament wants, the Parliament can.
Okay, sir.
It is unlikely that the Parliament will go against the wish or recommendation of the this Parliamentary Standing Committee. So far as the constitutional provision is concerned,
okay, sir.
This direct ADC, it seems impossible.
Okay, sir. Yeah, I think we can wind up now. Parliamentary committee has not put up the provision recommendation, so it is not likely that autonomous districts will enjoy financial the Native Americans in US. So anyway, I would like to thank our resource person, Professor Doungel, for the very detailed lecture and the question and answers. And our principal, Professor J. Zaurama, is here with us. He has joined during the session. So I have already given the brief profile of our principal, and so I will straightly invite him to give him a short time to say anything about not particularly regarding the issue, but regarding the webinar or the college. So I'll give Professor Zaurama the chance to speak.
Thank you, Dr. Roland, our host tonight. First of all, I'd like to give my appreciation to the Department of Political Science and the Department of Commerce, Government Jayabona College, organizing this kind of international webinar. And secondly, I'd like to congratulate our resource person, Professor Doungel, for his beautiful, enlightening, and well-documented lecture. From the study, we came to know a great deal about the tribal people of USA. Sir, you have shown us your expertise in the constitutional studies of especially America and India. And from the lecture, it seems that we, the Indian tribals, are very much better off than the tribal people of USA. I think you had greatly enlightened us from our ignorance about the tribal people of America. Thank you so much. Thank you for everything. Thank you for the organizers. Good night.
Thank you.
Okay, thank you, sir. Now, I will call Alwala, is the head of Department of Commerce and organizing secretary of this webinar, to give a vote of thanks. So, till the end, I will hand over the session to him. Thank you.
Thank you, Sir Nandika. As we have come to the end of our meeting, I would like to express our gratitude in brief. First of all, we are grateful to the principal of our college, Professor Zezo Rema, for supporting us to organize this international webinar. And Professor Doungel, we are indebted to you for accepting our humble invitation as resource person and for the wonderful and insightful session. We are looking forward to work with you again in the future. I thank all our 150 strong participants here tonight. The success of our webinar depends on your active participation and cooperation. Your e-certificate will be mailed to you once you fill up the participation form. You may check in the chat box, and the link will be open for about 1 hour after closing the meeting. And last but not the least, I thank the organizing team, both the Department of Commerce and the Department of Political Science, as well as the faculties of our college for our teamwork to make this international webinar a reality. Thank you all. And even though for Professor Doungel it is morning, and sir, please have a nice day. Thank you all. Mang Travek Ule.
Okay, thank you, Sir Mona. So, before we log off, you may fill up the form for each certificate. It is there in the chat box. In the chat box, we have pasted a link. There you can enter your personal details for each certificate.
Again, mo harsad na. If anyone face difficulties in getting the e-certificates, please feel free to contact us. I will try to solve it. The e-certificate will be automatically generated and mailed to you in your account. So there may be some problem for some technical issues. It can arise. So if anyone face difficulties in getting e-certificate, please feel free to contact the organizing team. Halo,